So today's webinar is geared towards public school operators. I'm talking about coverage for non-certified employees based on recent legislative changes to the Connecticut Paid Leave Program and Connecticut FMLA. So for our agenda today, we're going to do an overview of Connecticut paid leave. We'll talk specifically about the effects of Public Act 25-174 on schools. And then we'll get into the specific responsibilities for schools under Connecticut paid leave and Connecticut FMLA. We'll have time for questions. And then while we're not going to be going through it in this presentation, we do have an appendix that also provides some further details about Connecticut paid leave from the perspective of the applicant. So this webinar, just to set the stage, because we do have a number of webinars coming up, excuse me, this webinar is specifically for public school operators, which are defined as a local or regional board of education. This does include the Regional Educational Service Centers, or RESCs, an interdistrict magnet school operator, a state or local charter school, an endowed or incorporated academy approved by the State Board of Ed, or a cooperative arrangement between multiple boards of ed as allowed by state law. So if you fall into one of those categories, you're in the right place, and this information will be pertinent to you. So what is Connecticut paid leave? The Connecticut Paid Leave Act was signed into law in 2019 by Governor Lamont. And what it does is creates a source of income replacement benefits for eligible workers who are taking time away from their job for qualifying health or family reasons. Couple of key points about the program. This is an entirely employee-funded program. There is no employer funding whatsoever. So covered employers deduct 1/2 of 1% from their workers' paychecks through payroll deduction up to the Social Security contribution limit. We refer to these as contributions. The employers then remit the contributions on a quarterly basis to us here at the Paid Leave Authority, and they're pooled into a trust fund. When the worker needs time away from work for one of those qualifying reasons, they will still apply to their employer for job protected leave under FMLA, but they will then apply to us at the Paid Leave Authority for income replacement benefits while they're out of work. We started paying benefits in January of 2022, and to date, we have provided over $1.2 billion worth of benefits to over 165,000 workers all across the state. We receive claims from every town and city across Connecticut. And this map just shows you utilization rates. So looking at a kind of per capita basis and seeing where utilization is higher in the red and purple areas, and then a bit lower in some of the light blue areas. The most important thing to remember, and what we often see a lot of confusion about, is that FMLA and Connecticut paid leave are not the same. They are different laws and they do different things, but they work in tandem. So FMLA, which many of you are probably familiar with, is the Family and Medical Leave Act. There are two laws. There's the federal FMLA and the Connecticut FMLA, and both have been around for over 30 years. But there are changes to the Connecticut law, which will affect non-certified school employees starting on October 1st of this year. Both of these laws, these FMLA laws, allow workers to take unpaid job protected time away from work for qualifying reasons, and they're implemented by employers and regulated by the state or federal departments of labor as appropriate. There is nothing in either FMLA law that says the employer has to provide income replacement to the individual when they're out of work for a qualifying reason. So that's where Connecticut paid leave comes in. We don't provide job protection, but we do provide that source of income replacement for the same reasons that are covered by FMLA. So I like to think of it as kind of opposite sides of the same coin, one side with job protection under FMLA, the other side with income under Connecticut paid leave. We are at the Connecticut Paid Leave Authority, which is a quasi-public agency of the state of Connecticut, and we oversee and administer the paid leave program. Just another reminder, paid leave is not the same thing as paid sick days. So during the 2024 legislative session, Public Act 24-8 amended the existing paid sick days law and made some changes which are being phased in over the next few years to cover more workers and eventually employers with one or more people working in the state. Then in the 2025 session, the law was again amended to require boards of ed and municipal employers to require certain employees use accrued paid sick leave at increments set forth in their collective bargaining agreements. But key differences between paid leave and paid sick days are funded by employers, and they are used for, if you think of kind of your more run-of-the-mill illnesses, routine colds, flu, can essentially be used for the employee for themselves or to care for a loved one with any illness. Whereas paid leave is employee funded and it's used for serious illnesses, serious health conditions. So think about a major surgery, cancer treatments, things of that nature. We do have a couple of links here. We have a one sheet that we've created, which talks about the differences between paid leave and paid sick days, and then also a link to the Department of Labor site with more extensive information about paid sick days. DOL oversees the paid sick days law, so any specific questions about that should be directed to them. Now we'll talk about the effects of Public Act 25-174 on schools. There are a couple of relevant elements that we'll talk through. It establishes the definition of a public school operator, which we've already reviewed. It mandates that employees of public school operators and elementary and secondary schools who are not required to be certified for their position are covered by both Connecticut paid leave and Connecticut FMLA. It also allows the paid leave authority the discretion to account for alternate pay schedules when determining eligibility and benefit calculations. And it establishes a separate eligibility requirement for school employees under Connecticut FMLA. And we're going to talk through each of those different elements. So starting on October 1st of this year, who will be covered employer under Connecticut paid leave? Employers with one or more people working in Connecticut are already covered, including nonprofits and private sector employers with a unionized workforce. We do have a provision for sole proprietors and self-employed individuals to opt in for coverage under Connecticut paid leave. The big change is that public school operators will be covered employers with respect to employees whose positions do not require certification under Chapter 166 of the Connecticut General Statutes. And the same goes for non-public elementary and secondary schools. Their employees who do not require certification will now be covered under paid leave. Who is not covered? The federal government is not covered, the state of Connecticut and municipalities, unless they have covered public employees. Railroads are not covered. And for schools, employees of public school operators and non-public schools whose positions do require certification under Chapter 166 will continue to not be covered unless those employees collectively bargain for participation in the program. So bottom line, non-certified employees will be covered. Certified employees will continue not to be covered unless they collectively bargain in. I mentioned covered public employees a few times on that previous slide. So what that refers to is non-unionized state of Connecticut employees, unionized state employees who collectively bargain in, employees of municipalities who collectively bargain in, and when that happens, both the union and non-union folks become covered. As of 10/1, employees of public school operators who work in positions that do not require certification will become covered, and employees of public school operators who do require certification will only be covered if they collectively bargain for inclusion. Now, talking about FMLA for a moment. So, under the federal law, employers with 50 or more employees within a 75-mile radius are covered, and that includes government entities of any size, which does and has always included schools. So, no change there. Under the Connecticut law, almost all employers with one or more people working in the state, as well as all state of Connecticut employees, not covered under the Connecticut law, the federal government, municipalities, railroads, governments of other states and other sovereign nations, but effective October 1st, public school operators, as to their employees whose positions do not require that certification, will become covered under Connecticut FMLA. One of the elements that we mentioned is that we at the authority through this public act have been given the discretion to make alternative determinations for eligibility and pay calculations for school employees. So we know that school employees may have choices of how they'd like to be paid over the course of the years. For example, over the 10-month school year, over the full 12-month year, perhaps over 10 months with a balloon payment in June. So what we're proposing is to take the employee's annual wages and divide by 4 to determine their quarterly wages. And this is different from how we determine eligibility and benefit payments for other employees. Our reason for doing this is to ensure equity in the calculation of eligibility and benefits. because if you have employees who work the same job, the same schedule, the same annual pay, and make the same contributions to the paid leave program, we want them to be eligible for the same benefit. But with the current way that we do calculations, employees who make the same amount and work the same job could have substantially different benefit payments. So we are soliciting comments on this proposed policy. I have a link there to our revised consolidated policies on our website. And we welcome comments. We would ask that if you do have comments on this, please send them to Michael Caesar. He's our general counsel. He's on this call as well. And if you can submit the comments by August 22nd, include revised consolidated policies in the subject line. So Connecticut FMLA, this is one of the other changes that we wanted to highlight. So under the federal law, no changes. The worker must have been employed for at least 12 months and worked at least 1,250 hours in the 12 months immediately preceding their leave, and the employer must have 50 employees within a 75-mile radius. Under Connecticut FMLA, for most employers, eligibility kicks in after 3 months of employment preceding the leave. But for non-certified employees of public school operators, they have to have been employed for at least 3 months during the previous 12-month period by that public school operator or non-public elementary or secondary school. The reason for this is to avoid folks automatically being disqualified from Connecticut FMLA after the summer break. Now we're going to discuss responsibilities under both Connecticut paid leave and Connecticut FMLA. We'll start with the contributions. So the worker's requirement is to contribute 0.5% of their FICA wages up to the Social Security limit. The worker makes those contributions, but the employer is really the one who handles the administrative side of deducting those contributions through payroll and then remitting them to the Paid Leave Authority. So the first step is to register as an employer with the Paid Leave Authority at ctpaidleave.org. We have extensive directions on our website for how to do that. Take that deduction of 0.5% from the employee's wages and remit those contributions quarterly to the Paid Leave Authority along with the required backup. We know that many folks use a payroll provider, so it's important to just check and ensure that the payroll provider is withholding the contributions appropriately and remitting them to Connecticut Paid Leave. It is ultimately the employer's responsibility, even if they're using a third-party provider. Here at the authority, we receive and reconcile the contributions, process any over or under payments, and impose penalties for noncompliance. To register with the Connecticut Paid Leave Authority as a new employer. So when you register, there are a couple of areas where we just wanted to provide some guidance for what would be the most appropriate selections. Again, on the How to Register page, you'll see detailed instructions for how to complete this process. One thing that you'll need to select is business type. And so the three that pertain to schools include non-public elementary or secondary school, public school operator in connection with non-certified employees, and public entity that is participating via a collective bargaining agreement. So if you are registering as a public school operator because of this change, and because your non-certified employees are now covered, you would select that option, public school operator in connection with non-certified employees. If at some point you had certified employees who collectively bargained for participation, that's when you would use that third option, the public entity participating via collective bargaining. Another area that we just wanted to provide some guidance on is the date you first had Connecticut workers. We use this information to determine the first date that contributions are required from. So if you're covered due to this new law, you'll enter October 1st, 2025 as the date you first had Connecticut workers. If it's the circumstance where the certified employees are bargaining in, then you would enter the effective date of the collective bargaining agreement. There's some other information that you'll be asked to provide, which includes the number of Connecticut employees, and this should include only the participating employees working in Connecticut. The total payroll for Connecticut employees, that would be the total payroll for, again, just the participating employees working in Connecticut. The payroll frequency, so the option which most accurately reflects the frequency your employees working in Connecticut are paid. and then how your business will remit payments on behalf of the employees. So will that be done through a third-party payroll provider, for example, or through you directly? One of the benefits of registering is a newer feature that we've rolled out, which provides employers access to some limited employee claim data. So, authorized representatives can request approval to access basic claim information, which would include the employee's name, their claim case number, whether they were approved or denied, and if approved, the dates of the claim and the weekly benefit amount. This is information that we do share via email, but the benefit of having access to this through the employer portal is that you can then see all your employees on leave in one place at the same time. So just the registration piece doesn't grant this access. There are a couple of additional steps for approval. We have a link to those additional steps on the site, but that's an important feature to be aware of. Talking about the paid leave contributions. So we've established the employer is to deduct and remit the contributions from the covered employee's wages. The contributions are technically due on the last day of the quarter. So first quarter contributions are due on March 31st, for example. But we know it's hard to end a quarter and also make those payments on the same day. So we do have a 1 month grace period following the end of the quarter. If the first quarter payments are remitted by April 30th, they're considered timely and there would not be any penalties or interest assessed. But if they were submitted later than April 30th, that is when the penalties and interest would kick in. Also important to know that employers cannot deduct more than that 0.5% from employee paychecks. So for example, if an employer missed a quarter of contributions, they cannot go back and retroactively deduct more than the 0.5% to make up for that shortfall. Additionally, employers cannot use employee contributions to pay for interest or penalties. Newly covered employers can register immediately. We have everything, set on our website for you to go in and register, starting as soon as you would like. Talking about responsibilities on the claim side. So it is, the onus is on the worker to start their claim. They submit an application either through ConnecticutPaidLeave.org or by calling AFLAC. AFLAC is our third-party claims administrator. They have a dedicated team here in Connecticut that specifically works only on our program. So if someone calls that 877 number, it goes directly to our team in Windsor. When the worker starts their application, they tell us their leave reason, and they will then receive some instructions from us on what kind of supporting documentation we need. There are 3 different buckets of documentation we ask for. There's identity verification, employment verification, and documents supporting the leave reason, which might be, for example, a medical form if it's for someone's own serious health condition. We are working on developing a school-specific employment verification form. It will ask questions like, is the employee working in a position that requires certification? Does the employee have the option of choosing from several different pay schedules? Additionally, on the form, we'll ask about holidays, shutdowns, and school breaks. So if a particular employee would not be scheduled to work during a school break under typical circumstances, then they cannot receive Connecticut paid leave benefits for that period. On the other hand, if the only reason they aren't working is because of the need for leave, then they would be able to get benefits during that time. And just as a note, this is also the way FMLA operates. So if the worker is not scheduled to work, the employer can't deduct that time against their FMLA allotment. When the worker files the claim, we provide this employment verification form to them. They'll give it to you, and then you can return it directly to AFLAC. The worker also needs to update their account with absence info and provide information about other sources of income they're receiving while on leave. And they do need to notify their employer about their claim. The employer responsibilities as it relates to claims are to complete and submit that employment verification form in a timely manner. Also notify the worker about PTO policies, including short-term disability policies. The only thing our law says is that a person cannot receive more than 100% of what they normally make if they combine Connecticut paid leave benefits with any other employer provided income replacement benefits like short-term disability. However, that short-term disability policy is a private contract between the employer and the insurance company. And so whatever terms are in that contract are going to stipulate how that benefit interacts with Connecticut paid leave. So it's important to communicate that to employees so that they understand what they may or may not be entitled to. And then finally, of course, refrain from discriminating or retaliating against a worker for filing a claim. At the Paid Leave Authority, in coordination with our partners at AFLAC, we determine eligibility. We review the supporting documents. We may request clarification if something is unclear or inconsistent, for example. We approve or deny the claim as appropriate, calculate the benefits, pay the benefits if approved directly to the claimant, either through direct deposit or a prepaid debit card. We monitor ongoing claims, investigate potential fraud, and impose penalties as appropriate. The Connecticut Department of Labor can hear appeals related to the denial of claims and to penalties. If someone is denied, we offer a reconsideration process. Oftentimes, it's just a matter of needing a bit more information or documentation in order to substantiate the claim. But if folks don't want to do that, or if they do and they're denied again, they can appeal with the Department of Labor. I want to address paid leave and how it works with collective bargaining. So, employees of public school operators whose positions do require certification under Chapter 166, so for example, teachers, they are not covered by Connecticut paid leave unless they collectively bargain to participate. Now, if one or more bargaining units bargains to participate in Connecticut paid leave, all of the non-represented employees would also come into the program and be covered. However, employees represented by a bargaining unit that did not bargain in will continue to be excluded from the program. We have adopted a policy regarding the effective date of participation in the program via collective bargaining, which is linked here. So participation can only be forward-looking, it cannot be retroactive. Couple of other important notes about this. Collective bargaining does not automatically result in changing the employee's rights to job protected leave, and certified employees cannot bargain for coverage under Connecticut FMLA as enforced by Connecticut Department of Labor. However, they may bargain for a policy that adopts some of the provisions of Connecticut FMLA, such as that eligibility after 3 months of employment and the broader definition of a family member when talking about caregiver leave. Now we'll switch to talking about responsibilities of each individual or group under FMLA. So the worker needs to notify their employer about the need for leave in a timely fashion. Typically, that means 30 days in advance for a foreseeable leave and as soon as is practicable for something unforeseen or emergent. They need to submit their FMLA application as necessary, including providing the employer with supporting documentation as requested. And they do need to comply with the employer attendance and call-in policies. The employer should have an established leave policy, including rules about PTO usage. They need to post the FMLA posters, process leave requests, monitor leave usage, manage the worker's return, and refrain from discriminating or retaliating. The Connecticut Department of Labor provides regulations about Connecticut FMLA, provides guidance to workers, and investigates complaints about Connecticut FMLA claims or discrimination. And then on the federal side, the federal government does those same things for federal FMLA. What do you need to do as a newly covered employer under Connecticut FMLA? Again, establish that leave policy, including rules about PTO usage. Please do remember, pursuant to Connecticut FMLA, you can require or permit your employees to use their accrued PTO during leave, but you cannot require that they exhaust it. You do have to allow them to retain up to 2 weeks of accrued time if they wish to do so. You also need to post your FMLA posters and provide the notice of employee rights under Connecticut FMLA and Connecticut paid leave, which is linked there. That's a Department of Labor document, upon hire and annually thereafter. Important things to tell your workers when they're approved for Connecticut and or federal FMLA, they do have to follow your attendance and call-in policies. They need to notify their supervisors when they're using FMLA leave. This is pretty straightforward for someone who's taking a continuous span of time off, but it becomes really important if someone is taking time intermittently. So they need to specify that they're using their FMLA leave. Workers are responsible for providing you, their employer, and us at the Paid Leave Authority with complete and sufficient medical documentation. Do keep in mind that there could be other laws beyond FMLA that would apply to their situation and possibly provide job protected leave, such as the Americans with Disabilities Act or the numerous laws that pertain to pregnant workers. And even if for some reason your worker says, I don't want my leave to be designated as FMLA, it is always the employer's right and responsibility to designate time that qualifies under FMLA as FMLA. And that's an important protection both for you and for the employee. I have a couple of slides that'll just go into some of the basics of Connecticut paid leave and Connecticut FMLA. So starting with the reasons that are covered. Medical leave is treatment for one's own serious health condition. This is by far the largest bucket that we see claims for. It's over 50% of all of our claims. This does also include serving as an organ or a bone marrow donor and pregnancy. Second most common reason is bonding leave. That is leave time to bond with a newborn or a newly adopted child or a child placed in the home for foster care. It is available to both parents and it can be used at any time during the 12 months after the child's birth or placement in the home. It does not need to be taken immediately. It just has to be taken within that first 12 months. In the case of adoption or foster care, it can also be used for pre-adoption or pre-placement activities, such as attending court proceedings. Caregiver leave is leave to provide physical or psychological care or comfort for a family member experiencing a serious health condition. There are two types of leave that pertain specifically to the military. There's military caregiver leave. It's pretty straightforward. That is leave to care for a family member who was injured during active duty in the armed forces. And then there's something called qualifying exigency leave. So this is leave for a parent, spouse, or child of an active duty military member that has been notified of an impending call or order to active duty in the armed services. This could be things like visiting the family lawyer to update the will before the deployment, or attending a sending off ceremony or a welcome home ceremony. There are 9 specific reasons that fall under qualifying exigency leave. And then lastly, there's something called the Family Violence Leave Act. This is a law that applies to all businesses or all employers, I should say, with 3 or more workers in the state. So this does actually apply to certified and non-certified employees, and it provides up to 12 days of job protected leave in a calendar year for victims of family violence or sexual assault for specific reasons, which includes seeking medical or psychological care or counseling, obtaining services from a victim services organization, relocating, or participating in court proceedings resulting from the family violence or sexual assault. This is also a reason for paid leave benefits. It's what we refer to as safe leave. So again, as I touched on at the beginning of the presentation, paid leave is really for serious health conditions as opposed to paid sick days, which is for those more routine or common illnesses. The key thing about a serious health condition is that it requires both incapacity and treatment by a healthcare provider. Some examples, this is not exhaustive, but some examples include an overnight stay in a hospital. If you have to stay overnight in a hospital, you're probably going to qualify as having a serious health condition. However, it could be a chronic condition where you see your healthcare provider at least 2 times a year for maintenance and monitoring of the condition. It could also be a long-term condition where treatment is no longer effective, but the person is still under medical supervision. So that could be something like Alzheimer's disease, terminal stages of cancer, et cetera. Incapacitation during pregnancy. So this refers not only to complications during pregnancy, but also just time needed for routine prenatal appointments. So these are just a couple of examples. Another big difference under Connecticut's laws, both FMLA and paid leave, are who is considered a family member. So under federal FMLA, a family member is a spouse, parent, or child under 18 or over 18 with a disability. Those are the only family relationships that are recognized for caregiver leave. In Connecticut, we have a more expansive definition, which includes parents, spouses, children of any age, siblings, grandparents, grandchildren, or a person related to the employee by blood or affinity. So related by affinity essentially means that if the worker has a close personal relationship that is like one of those relationships that I just listed on the previous slide, they can take caregiver leave to provide care for that person, regardless of if there's a biological or legal relationship. This is obviously situation specific, but just to provide you with a couple of examples, there might be an aunt or an uncle who has a relationship with the worker that is more like a parental relationship, and that aunt or uncle relies on the worker for unpaid care. That would be considered a relationship by affinity. A common example is an unmarried significant other of the employee. They have a familial spouse-like relationship, but they're not legally married. And Connecticut doesn't recognize common law marriage, so that would qualify as a relationship by affinity as well. Last thing I want to touch on is just types of leave and the duration of leave available. So there are three different ways leave time can be taken. The first and most common is block leave. So that's where the employee is not going to be working at all for a continuous period of time for a single qualifying reason. For example, the employee is having surgery and they need to be out totally for 6 weeks for recovery. The doctor says you cannot work at all for 6 weeks. There's also reduced schedule. So this is typically when an employee is going from a full-time schedule to a part-time schedule for a duration of time. So let's say, for example, the employee normally works 9 to 5 Monday through Friday, but after their surgery and they get back to work, they're doing extensive physical therapy and they need to leave at 2 o'clock every day to go to those appointments. So that would be a reduced schedule leave. And then there's also intermittent leave. That's where the employee is going to be absent sporadically for smaller periods of time. This is often unplanned and often in the case of someone who has a chronic condition that can flare up unexpectedly and when they can't predict it. So let's say the employee suffers from migraines. They don't know when they're going to have such a severe migraine that they can't go to work, but they know that it happens. They could apply for intermittent leave so that they have some income replacement when those things occur. In terms of duration, there are up to 12 weeks available in a 12-month period for most leave reasons. What we do is when someone applies, we use a look back method. So we will look back at the previous 12 months and see what, if any, leave they have used in that 12 months to determine what remains. There are an additional 2 weeks available for incapacitation during pregnancy. This could be time used for prenatal appointments. It could be time used for a complication related to the pregnancy, or it could be used for an incapacitation that's unrelated to the pregnancy. So, for example, if someone is pregnant and they fall and break their leg, they can receive that additional 2 weeks during the pregnancy. The 2 weeks goes away once the child is born, so it can't be tacked on to the end of their 12 weeks if they don't use it during the pregnancy. And then lastly, leave under the Connecticut Family Violence Leave Act and benefits for those same reasons are capped at 12 days in a calendar year. This slide just has some links and some phone numbers for you for easy access. There's a lot of information on our website. We've also provided the information to contact AFLAC directly. That's where if you have an employee who's already filed a claim and they have questions, they can call AFLAC, and then some different links to the Connecticut and federal departments of labor. As I mentioned, and I'm not going to go through, but the appendix here is useful just to know a little bit more about Connecticut paid leave from the claimant perspective, what they can expect when they do an application, what kind of documentation they'll need to provide, et cetera. So we will share this with you for some further information.